University of Michigan Law School, Leah Litman. Leah, thank you so much for joining me.
Thanks for having me.
So we have major Supreme Court news on two different fronts, but let's start first and foremost with same-sex marriage, Obergefell. Can you explain what the Supreme Court is looking to do right now?
So, Obergefell versus Hodges is the marriage equality decision that struck down state laws that refused to license or recognize marriages between same-sex couples. And what has happened recently is Kim Davis, who is literally obsessed with gay people, filed her latest petition for certiorari, asking the Supreme Court to hear her case. And
So
in
she,
asking the Supreme,
Kim,
oh, sorry, go ahead.
and Kim Davis is the county clerk down in, is it Kentucky? Is that correct? Who had
Yes.
initially refused to give marriage certificates to a same-sex couple, and she got sued and spent a few days in jail.
Exactly. So she was sued. She refused to comply with the order. She was put in jail and fined. And so, as part of her continuing to challenge, that course of conduct, she has asked the Supreme Court to consider overruling Obergefell versus Hodges, the marriage equality decision.
So when is the Supreme Court going to hear arguments on this case?
So they won't necessarily hear arguments. All she has done is ask the Supreme Court to grant what's called a petition for certiorari, to consider whether to hear arguments and schedule full briefing. So we aren't going to know whether they are even going to grant certiorari, i.e., hear her case, for at least a few months.
Okay. Is there anything to suggest whether or not they might grant her request?
So I think the odds are extremely low for a few reasons. One is she's tried this tack before. She has previously asked the Supreme Court to review her case, involving her being penalized for refusing to issue marriage licenses. In that case, Davis versus Ermold, kind of the same case that she has once again tried to bring up to the Supreme Court. Even Justices Thomas and Alito said this case is not the case to revisit Obergefell versus Hodges. So if even those guys have taken a pass on this case as a way to overrule Obergefell versus Hodges, I just don't see the court taking up that issue in this case.
But if Alito and Thomas are both saying this case is not the case to be able to revisit Obergefell, does that suggest that there is openness for them? They just want to make sure that the vehicle that's brought is the correct one so that they have the best chance, the best opportunity to be able to strike it down.
That's exactly right. I mean, Justice Clarence Thomas actually wrote explicitly in his separate writing in Dobbs, the decision overruling Roe, that he affirmatively wanted to overrule Obergefell versus Hodges, as well as other decisions. So we already know that both Thomas and Alito are interested in overruling Obergefell. We just also happen to know that this particular case is not the case in which they want to do so.
Isn't this the same legal concept that would also apply to interracial marriage, for example? And then what are the implications there? I mean, Clarence Thomas himself is in an interracial marriage, and so isn't there some inherent conflict that somebody like him would stand to get hurt from by virtue of moving this thing forward?
So notably, when Clarence Thomas ticked off all of the decisions he wanted to overrule, on that list were decisions protecting access to contraception, decisions protecting marriage equality. But what wasn't on that list? Loving versus Virginia, the decision that struck down bans on interracial marriage. Now, what he would say is there's a distinction between Loving, the case invalidating bans on interracial marriage, and cases like Obergefell or cases like Griswold, which protected access to contraception. He would describe Obergefell and Griswold as cases involving so-called substantive due process, basically recognizing rights that are not specifically or explicitly mentioned in the Constitution's text, whereas Loving versus Virginia was decided not on the basis of just substantive due process, but also on the basis of equal protection, because distinctions that are drawn on the basis of race trigger the most heightened, most searching form of judicial scrutiny. Now, of course, marriage bans also discriminate, right? And I think violate the Equal Protection Clause. But the decision in Obergefell did not specifically and explicitly say laws that discriminate on the basis of sexual orientation trigger meaningful scrutiny, just like laws that discriminate on the basis of race do.
So even if this Kim Davis case is not the vehicle to be able to try and overturn Obergefell, do you think it's a fair statement to suggest that this Supreme Court is just waiting out the correct vehicle and that Obergefell is is at risk, is in some degree of danger. They're just waiting for the right way to be able to do it.
I think the more likely scenario is the current court, such as it is more likely to undermine Obergefell, marriage equality, and LGBT rights by recognizing First Amendment exemptions for people who object to marriage equality, to not have to comply with laws that bar discrimination on the basis of sexual orientation. I am not going to rule out the possibility that the current court might, right, one day overrule Obergefell
Yeah.
versus Hodges. I mean, the Republican Party platform did call for them to appoint justices who would overrule Obergefell in addition to overruling Roe. I just don't think that is going to happen right now. But that's not to say like people shouldn't be concerned about the future of marriage equality, LGBT rights, and what is going to happen at the Supreme Court.
Okay, so let's talk about something that's happening at the Supreme Court, certainly more quickly than any impact on Obergefell, and that is the potential for this court to strike down Section 2 of the Voting Rights Act. We've already seen this court whittle away at the Voting Rights Act. Section 2 basically allows these opportunity districts to exist in states across the country. We've seen that a number of states in the South have been challenging this stuff: Louisiana, Alabama, Georgia, Florida, and these opportunity districts, these black majority districts, have been upheld. What is the Supreme Court looking into now, and what are the risks facing us?
So, what the Supreme Court is looking into is whether this law, which again sometimes requires states to create opportunity districts, actually discriminates on the basis of race in violation of the Constitution. So, basically, they are considering whether prohibiting white legislatures from discriminating against Black voters by refusing to create districts in which they have political opportunities is itself a form of anti-white racial discrimination. It's like the argument on affirmative
Right.
action, but put into voting rights.
And so, is there anything to suggest how the Supreme Court might rule? Is there anything that you could read from the tea leaves? Anything that the justices have said themselves that might lend itself to this idea that they are willing to gut the Voting Rights Act?
Signs are very concerning here. So, a few years ago, the Supreme Court heard another challenge to race-based redistricting and the Voting Rights Act in a case out of Alabama in Merrill versus Milligan, Allen versus Milligan. And what ended up happening in that case is four Republican appointees said they would have effectively gutted what remained of the Voting Rights Act and its protections for redistricting then and there. But Justice Brett Kavanaugh wrote separately to say he wasn't sure he wanted to do so now based on the argument that Alabama had presented him in that case, but that he would be open to doing so in a future case on a slightly different theory. This is that future case. So the fact that we know there are at least four votes and another justice who's open to it, the fact that the justices opted to put this case on their calendar again and to specifically and explicitly invite the parties to focus on whether the Voting Rights Act is unconstitutional racial discrimination, all of that is very concerning.
Does the fact that they scheduled these arguments for the very beginning of the upcoming Supreme Court term, they scheduled them for October 15th, does that suggest that they might want this case argued and decided in time for the 2026 midterms, knowing full well that we have a Republican Party that is perfectly content to redraw maps mid-cycle to try and extract as much political benefit out of them as they can?
It is a very concerning sign, and I wouldn't rule out that possibility. I mean, as the Chief Justice himself talked about in the birthright citizenship case, when the court wants to go fast, they go fast. And when they want to go slow, right, they go slow. They dragged out Donald Trump's immunity appeal, effectively guaranteeing that he would not face trial before the 2024 presidential elections. Now, all of a sudden, they're in a huge hurry, right, to tee up the constitutionality of the Voting Rights Act.
Which by the way, was a case that they decided unto themselves to bring up. Like there were no plaintiffs here that were looking to relitigate Section 2, the legitimacy of Section 2 of the Voting Rights Act. They asked to hear specific arguments on this question that wasn't initially posed to them by the plaintiffs.
And this is exactly what happened, what you're describing in Citizens United, the case that launched the Supreme Court's war against campaign finance regulation. The parties in that case did not initially ask the Supreme Court to strike down the ban on corporate independent expenditures in elections. Instead, the Supreme Court teed up that question. They issued another order saying, we want you, right, to brief and argue that this law is unconstitutional. And of course, they ended up deciding the case on that ground.
In terms of the amount of districts that would be impacted, do you have any idea of the number of districts across the country roughly that are protected by Section 2 of the Voting Rights Act right now?
I don't have a complete number about the number of districts that a decision striking down Section 2 would necessarily call into question. I've heard estimates that it might be in the 20s or 30s, but I don't have a firm number.
Okay. Aside from the two cases that we've spoken about today, the prospect of Obergefell being revisited, and of course the guarantee of Section 2 of the Voting Rights Act being re-argued right now, is there any other cases that are coming up in this Supreme Court term that you're keeping an eye on?
Several big cases. So there is a challenge to bans on conversion therapy. That is, people are arguing that states cannot ban conversion therapy. This would effectively, make it legal for states to discriminate against gay, lesbian, bisexual, transgender individuals, at the same time that they refuse to strike down bans on gender affirming care. Last term, they're also going to be deciding the question about whether states can exclude trans athletes from participating in sports. They may even decide whether states have to exclude transgender athletes from participating in sports. So those are three of the big cases on the court's docket. And of course, we have no idea what other big Trump-related cases might make their way to the court on the shadow or emergency docket either.
Yeah, like legalize, like Trump can just legally kill anybody he wants, like walk into people's houses and well, I got to ask too, there obviously is a lot of negative prospects on the horizon. Is there anything happening at the Supreme Court that might offer any glimmer of hope? Is there any rights that may be protected in this upcoming term? Is there anything that you can look at that you draw some faith from?
So the glimmer of hope that I was going to identify was not going to be a right that will be protected, but instead the fact that the court's public approval ratings are plummeting to all-time lows. And I say that as a positive because I truly think that the way out of this is raising awareness and getting people to pay more attention to the Supreme Court and recognizing that the court has to be part of conversations about how to reform our constitutional democracy and get us out of the mess that we find ourselves in right now.
Well, that's a great point as well. I would also flag for anybody who's watching, if you'd like to support Leah's work, please grab a copy of her book called Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. I'm going to put the link right here on the screen and also in the post description of this video. Please, if you can, help support the work of independent media folks like Leah Litman. Thank you so much for taking the time. I appreciate it.
As always, thank you.